Initiative 42 was something that was relatively foreign to me up until recently, and I think that's probably true with a lot of us. We had heard a lot about it, but maybe didn't hear information that was clear to us. And one of the biggest struggles that I have seen is there's so much information out there. And I've tried to break it down in a fashion, and in full disclosure, I went to school at Belmont, graduated from Belmont High School. I went to Northeast Mississippi Community College, ended up going to the University of Mississippi and graduating there. I believe in public education. We are blessed to have good public schools in North Mississippi, and I don't think that is by coincidence that we have those things. But as I began to look at Initiative 42, I tried to attend meetings to get some information. The Secretary of State's office was putting forth some meetings, and so it allowed me to have a little bit of basis. But one of the things, especially in the last 2 or 3 weeks, I began to have phone calls with people asking me, what's your take on Initiative 42? We have people that are really concerned, they're really confused, and it's not a Republican-Democrat issue per se, it's the issue of not sure what is going on. And now we're spending millions of dollars on television advertisements that are not helping clear the air at all. So what I have tried to do in several situations is take my opinion out and lay out the facts, and I encourage you to share with your friends the same things, because I will be fair and tell you I don't know and have all the answers when it comes to education. I don't know that I have the answer that says this is exactly how much funding is necessary. But that's not really what we're talking about. We're talking about amending the Constitution of the state of Mississippi, the supreme law of the state. And that is why we need to look very carefully at the language of the amendment. And one of the things that I have given you, the very front page, is directly from the Secretary of State's office, which in red has the current law as it is written in the Constitution. It also has the language for each initiative, Initiative 42, and then the alternative measure. The reason I lay that out in front of you is there are websites, there are commercials that are saying a lot of things. None of them seem to be posting the language of the law we're actually adopting. If you will look on the second page, you see the Initiative 42 language in a fashion that anything that is underlined is new language that is being added. Anything that is struck through is language that is being changed. If it is neither underlined or struck through, it's a word that gets left from the original language. The issue I think that we're looking at is perception versus reality. Many people who've talked to me recently, especially, and by the way, also in full disclosure, my mother's a retired third grade school teacher. I mean, many of my friends, colleagues, family members are in the education system. We want to be pro-education in this state. But what we don't want to do, I think, is bind ourselves with law that we don't understand or that opens up issues that we do not understand. The first thing that happens is you see that there is a fundamental right that is added language. And from a legal standpoint, when you add fundamental right to something, it is a very high level of scrutiny. It is a very concerning type of language that gives the ability to say, hey, we're not meeting the obligation. You see also that the legislature is struck through. We're removing the word legislature from this. We're adding the word state. We're taking out the words general law. And the key thing is that what we're going to provide, if under Initiative 42, is an adequate and efficient system of free public schools. Now, the concern, I think, is when we say shall, and it says the state shall provide. Shall is a requirement. It's not a may, it's a must. But when we talk about the words adequate and efficient, they are subjective. Every one of us in here can have an opinion on what is adequate and efficient. I used an example the other day. If you have a child that turns 16 now, they want a car. Is that pretty much the same? would your opinion of what automobile is adequate and efficient be a touch different from your child's? And yet it might be a car that gets them up down the road well, but they might say, hey, it's not adequate and efficient because it does not have this feature or that feature. So the key thing I want people to understand is the language opens up the subjective of adequate and efficient. Also, I want you to notice, before we get to the last sentence, is what is not in here. And I've had many good friends and folks that are retired educators who have asked my opinion. And here's what people who are 442 believe they're for. Fully funding education to the MAEP formula. That's what you will hear over and over again, which is something that if they feel should be done, that's fine. If not, that's okay too. The problem is that's not in this initiative. That's what has been framed as the argument, and folks, they didn't use their own words. And the next two pages the next page is the actual ballot, and we'll come back to that. The back two pages are actually the petition that many of you may have signed. And the petition itself was presented in a fashion where someone said, this is to put more money in our classrooms. And that sounds like a wonderful thing. But the language is not on this first page. If you look on the second page, you'll see the section 201, which shows the language you and I are talking about. Then there's this discussion about a 7-year phase-in where there'll be no tax increases. There'll be, 25% of the revenue increases each year will be added. Have any of you heard that there's a 7-year phase-in? There's no 7-year phase-in in the language of the document. That's the concern. Many of your friends and family members who may be for fully funding MAEP and are for doing it out of revenues that may or may not come are 442, and they don't understand that it's not in the language. So the first thing I would ask you to do with your friends and neighbors and you yourself, please show them the language. Ask them to read what literally the language of Initiative 42 is, and what's not there is as concerning as what is there. I guess the final sentence of 42 is another issue to look at, is that we have shifted, as we struck the legislature literally out of the Constitution as it relates to public education, that we're saying we shall have an adequate and efficient school system. And the chancery courts of this state will have the power to enforce this section with injunctive relief. If someone says we believe there is an inadequacy or an inefficiency, it opens the door for a suit. A lot of people, and I believe they truly believe this in their heart, says no, if the legislature fully funds the MAEP formula, that cancels this. There will be no problem. No, if I think that's inefficient or inadequate, I still may sue. I think there is no limitation. And with all due respect to some attorneys and judges who've spoken to this matter, I don't understand how you can come to a conclusion that there will be no suit when the language is clear that it's a subjective, adequate, or efficient, which we've all already agreed is by interpretation of our own ideas. We remove this authority from one branch of the government and give it to another. There's been a lot of discussion over Hinds County. And the reason that is, there's no magic formula behind it. If you sue the state of Mississippi, that's the proper venue, is that you go where the capital is. You go to where the seat of power is. So that's why when people say, hey, it's a Hinds County Chancery Court, that's the reason. The amendment itself says Chancery Court, and if you sue the state, you go to Jackson. People have talked about the rights to appeal, etc. I think, again, we're missing the point. You're asking us to amend the Constitution, remove one branch of the government from legislative branch, to remove them from power, to put that into the hands of the judiciary, of which anyone who believes something is inadequate or inefficient could file suit. And I see it as an attorney, I see it for what it is. it is a door open to a lot of litigation in this state, and it's not something that particularly helps our district and our state as it relates to functioning an efficient and adequate system. I do believe that if you wanted to say, legislature, you shall, through an initiative, you shall fully fund MAEP each and every year, you could have said that. And they chose not to. They chose to talk about a lot of other things. They chose to take power away from the legislature, put it in the hands of the judiciary. And the one thing I believe about representative government is if your belief is that the legislature is not doing their job, you have the opportunity to run against them. You have the opportunity to support another candidate. That's the way our system has operated for a very long time, not let's go down to the courthouse and let's file competing lawsuits, because I believe if we all sit down here and discussed it, we would have different ideas for education. And anything that doesn't suit me, I could go to a court and demand to have a judgment on whether that's inadequate or inefficient. So I guess in total, the biggest thing I've asked people to do is please find the language and read the language. And I will say this, and I've tried to be very factual and stay out of opinions, but I have gone to the website for the proponents of 42, and I cannot find the language of the very amendment that they want us to pass. I see a lot of information about, do you want to do something for your children? Do you want to do something for the future and jobs? But if you're not willing to put the very language of the amendment you're asking me to pass, it's concerning. So, and I'm glad to take questions and will answer to the best of my ability. Yes, ma'am.
Is this the actual ballot?
Yes, and that's one thing.
This is very confusing.
The ballot itself, and I've tried again to make it to where we're not unprepared, because I think the key is, and I think we would all agree with this, although we may have a feeling one way or the other how we want it to turn out. What we want to see is that if I walk into the voting booth, that I get to vote for what I want to, that I'm not actually confused by commercials or confused by individuals making statements. But the ballot itself, and I've tried to give you a blank one here now. You're welcome to look at all other ballots, but in this package, and I'm sharing this with you that you might share with your neighbor. Your neighbor
This is the one that's on the internet right now. I mean, it's being sent out, and it's
right.
a little different from this one.
Well, this is pulled directly off Secretary of State's website. And the
I see it. Gotcha.
And what I hope this will do for you, because each of you, and you may very well be for 42. If you are, same thing. I challenge you to read what you're voting for. But you're going to have friends potentially that are not sure, and I want to have the opportunity to lay something in front of them that will let them be able to decide and see what the language is. Yes, ma'am.
One other thing, I have been told that this judge can also, if he determines that more money needs to be for the school system, that he can pull money from other departments, like health department or whatever, and put into the school system.
To be fair, I don't think the judge could pull money. What the judge could say from an injunctive standpoint is he could say to the legislature, this is the number, fund it. It's their problem to have to come up with it. And the state of Mississippi, unlike our federal government, cannot print money. We cannot go create money and we have a balanced budget. It will come out of some other pot, but it will be upon the legislature to have to find a way to do what the judge has said. And you brought up another point. I do believe when you look at the actual language and the standard is adequate and efficient, I don't think we're just talking about money. I might deem that the curriculum that we're under is inappropriate. Well, therefore the school system is inadequate, in my opinion, or it's inefficient. So I want to see a different curriculum. I think I could say, you know what, it would be a lot better if there was one school per county. That would be efficient. I can make that argument to a judge. How will a judge rule? Would we appeal it to the state Supreme Court? Very well. What does it cost when you go into the court system? So the state of Mississippi not only is having to fund these things, they're having to defend these things. And so that's, I think, and I stand firm on this, that when you use the words adequate and efficient, whether someone is for or against 42, when you use the words adequate and efficient, you have opened the door for anything the mind can imagine to sue. And as an attorney, I'm proud of what I do. I like being an attorney, but I can tell you, if an attorney can find a spot to set him or herself down, they will, and it's wide open for that. And there's current litigation going on now. That's another thing people have said, is that we need this. We want the legislature to do what they said they would do under the MAEP formula. Well, there's a suit right now already out there, so they don't need to. If someone says we need to change the Constitution to hold someone accountable, we do not. That power is already there. So that's my biggest concern, is that we have opened up a Pandora's box of litigation. And I will tell you this, if you want to get creative with it, I do believe there are people, and I think there are people who think, well, maybe there's too much money going to education. You could sue for that. Now, I don't know that I agree with that, but if someone could deem, hey, you know what, we could do this more efficiently, again, if we had less schools, we had less administrators. I think it's open on either side. Anything I deem inadequate or efficient, I'd go knock on an attorney's door, and they would file suit for me.
The thing that scares me is I I live in DeSoto County. We have a very good school system. We have the largest school system in the state now. And what's to stop Judge Blowhard in Hinds County from saying, well, DeSoto County, you've got too much money. That needs to go to Sunflower County or
and I think that's correct. Walt's point was there are school districts in the state, DeSoto for instance, that have been very successful and been good stewards. Let's call it what it is. You're good stewards of the assets, of the money, of the property taxes, etc., that are put in front of you. And if someone is suing on behalf of their school system, which is not as good a shape, one of their arguments may be, hey, to be adequate and to be efficient, it would do better to reappropriate some of these funds. And someone says, well, that can or cannot happen. I think anything that the mind can create as far as a suit is possible. And people say that's fear-mongering. I disagree. It's being factual, because let's be very clear. The language of 42 was written by an attorney and a proponent of 42. You could have said what you meant to say. The pen was in your hand, and you chose instead to make it vague and troublesome. Yes, sir.
Daniel, can you explain how many votes it's going to take to everybody for this to pass?
Sure. The way I understand it, going back to the ballot, which is very confusing, what you're going to see is, and there, by the way, there has been litigation over the ballot itself already. So when people keep saying there's not going to be litigation if MAEP is fully funded, I think the actors themselves have even shown that that's not going to happen, because they've already sued on the ballot itself. The first thing that you're going to vote for is, do you want to change the Constitution at all? Either item. It's my understanding that that is a 50%, it's 50 plus 1. If you vote for approval or against approval, and this is where it's really confusing, is that the first vote is, do I want to change it at all? Yes or no, for or against. If 50% plus 1 vote for it, then you go to the second question as to which alternative will be utilized. If greater than 50% vote against it, then you don't have to choose. But you need to vote both, because the way it's been explained in some situations is, if you vote against it, for instance, and the 4 is carried, in other words, it's going to be a choice. At that point, do you want 42 or do you want 42A? So that's the way I've understood that it's going to work, but you need to vote in both places.
So there's a confusion in that lean towards accidentally passing something.
A little bit. I think the concern is that those who are against 42 have said, vote against it twice. Well, you can't vote against it twice. You vote against it once, and the second vote is either for 42A or 42. And I think people are a little confused because on the second vote they're looking for the no, and there isn't a no or against. So let's talk about 42A just a little bit because of that, because what the legislature did, they had an alternative. I think, you know, once the proponents of 42 have the legal requirements to have something on the ballot, you can't undo that. But the legislature chose to offer, through its power, an alternative that if we're going to amend the Constitution, and that language, again, is on the front of the handout, is the legislature shall, by general law. So it keeps the power in the hands of the legislature by passing law, general law, provide for the establishment, maintenance, support of an effective system of free public schools. And now I'll be honest with you, it's better language. Keeps us a little bit out of the Chancery Court, but effective is still subjective. So I think you still would see more litigation, and that's why many people are saying, look, we're going to vote not to amend the Constitution, which is a no on the first vote, but if we had to, we prefer 42A over 42. It's the lesser of evils.
All right, let me ask you another question.
Yes, sir.
On the back of this first page, it shows initiative 42. And it says protect each child's fundamental right to education opportunity. And you strike the legislature.
Yes, sir.
I don't know who that is. Who is the state?
And I think that's another vague area. And would 42 proponents rewrite this given the opportunity? I don't know if they'd ever admit it, but I think they would because they've created a problem. We did take the legislature out. It was very clear that too was to make the funding rules. And we put the word the state in. I'm not sure I can define who the state is. Is the state the governor?
That's ambiguous.
Is that the governor? Is it the people? Is it, you know? So again, the language as it's written, and I have used this analogy with some folks that are adamantly for 42, and I said, look, even if you believe that MAEP should be fully funded each and every year, this does not say that, and it's the wrong vehicle to get to the destination you're trying to go. I'm concerned. I think it's the most important thing on the ballot, I'll be honest.
Where do you get the idea that this judge would be appointed in Hinds County? Because that's a seat state government.
That's correct. Yes, sir.
Would it be impossible to appoint that judge in Greenwood, Mississippi, or
I think you would see a lot of challenges because people would say, "Hey, look, that's a standing venue rule," or you know, why you would have to show a need to move it. In my opinion, I think when you say Chancery Court and you're suing the state, you got to sue them in Jackson.
You can't overlook buying votes. So.
Well, I mean, I think it's. I mean, I understand, and I will say that to me, again, the language that's in the amendment, what is adopted will be the law, not my opinion, not the 7-year phase-in. And I have also, I believe it's true that the legislature can fully fund MAEP the first thing out of the gate in January and still be subject to suit. That doesn't cure anything. So that's my biggest concern as far as the language has not been clearly put out for the public to consume. And at the end of the day, when we see the language, if you're for it or against it and you understand it, that's your right to vote that way. But if you don't understand it and you're concerned about it, then you're amending the Constitution. This is not the legislature passing a law and in the same session they might amend something that they passed. This would have to go back through an additional constitutional amendment process if we didn't like what we got. So I do lay, if there's blame to be laid for confusion, I lay it at the feet of the drafter of the amendment. And was that intentional? I can't tell you that. But we chose to use the word state, which is an ambiguous word. We chose to use subjective words of adequate and efficient. We chose to remove the legislature and put it in the hands of a judge, a judiciary, of which you don't have a vote in that person's election. And that's, you know, that's the things that concern me as an attorney. And I've shared this with my friends, and some folks agree with me, some folks don't. but I've challenged them to read it. And I wish, I wish our public school system well. I believe they do a great work, and our teachers do a great work, and a job they don't get thanked for enough. But this is not something that will cure the ills of the education system in the state of Mississippi.
This reeks of dictatorial authority.
It also reeks of putting us in the hands of a judiciary where there's not a lot of recourse. They say, well, you can appeal. Well, if I lose it on appeal, then what? And I think that, again, if I have a gripe about something the legislature is doing, I have a vote, and I have the phone number, the opportunity to reach out to that legislator, and I believe they're receptive to that. But at the end of the day, this language does not accomplish, nor does it say what people, and I'm going to go back to my original position where I'm a little frustrated. I think walking up to someone and saying, if you'll sign this, it will put more money in the classroom without any tax increase, is somewhat disingenuous, and it misleads people to vote for something that will end up injuring the system more than it will
And
help
their
you.
commercials are totally misleading.
I believe that, again, the money that's being spent on this race, there's a great deal of concern about where the power lies. And at this time, it lies with the legislature, representative government, people that you can elect. You shift it over to the judiciary, and then it becomes a real problem. But I would encourage folks to read the language, and the key things are, there is no mention of MAEP funding. There is no mention of a 7-year phase-in. The word funding is not even used, and it's been portrayed as a funding issue. And I again, I want to try to help shed as much light on this as I possibly can. Yes.
Kind of a what-if question, but if 42 passed and the Chancery judge ordered the legislature to fund, what if the legislature and the governor took an Obama approach and said, we're not going to enforce it? What would happen then? What penalties could he impose?
Well, he has injunctive relief. Again, I think that's another possibility, is what do we do if a judge orders something and the legislature says we're not going to do it? Now we have a conflict that we've created via constitutional law, via amending the Constitution, that's not there today, because the governor has the power of veto. If he doesn't like the funding side of it, we don't have the ability to veto the judge. And there's been a separation of power argument from the proponents of 42, which I'm missing, because you're shifting things into the hand of the judiciary. Yes, the legislature will continue to appropriate, but every time they appropriate, let's just sit back and wait when the budget comes out to see who views that as inefficient or inadequate, and then the suits come. But I don't know that I can answer if there was a complete impasse, but it's another thing that's being created by not using good language. Yes?
Daniel, I've heard 2 attorneys that have practiced in the Chancery Court in Hinds County, and they say it is an absolute joke. It is absolutely unbelievably a culture there that we're the asbestos and tobacco lawsuits. I mean, it'll create a whole new industry.
And as far as the judiciary goes, and I don't know the chancellors in Hinds County personally, they may be the brightest chancellors on the planet, but it doesn't matter. I doubt they are experts in education law and budgeting, a multi-billion-dollar issue. And I honestly don't think that they would have the resources and the background to make the decisions that need to be made by the majority expenditure of our budget. K-12 spending is the #1 area where we spend money. And to turn that over to a judiciary official, and I heard one argument today, you could ask for a jury trial. Again, who has the expertise to know what's going into it? So I'm a little confused why the language is there as it is. But again, my biggest concern that I go back to is you have pulled a bait and switch. you have represented that this fully funds education. Now, you don't even say, now you see it just fully funds education, which is open-ended. But you've said that it would fully fund the MAEP formula, and it does not say that. And you told people with your petition, and even on the language of the document you asked them to sign, that no tax increase, because over a 7-year period, we would only take 25% of your revenue gross, and therefore we would fund this fully. And again, you're projecting that you're going to have revenue growth that you may or may not have, but all of that aside, it's not in the language of your document. It's not in the language that goes in the books. You don't have those 7 years per the law. Yes, sir.
First a comment and then a question. This gentleman over here raised a question that I was thinking of in 1832, 3, whatever, in an Indian case, Cherokee Indian case, when Andrew Jackson said of John Marshall has made his decision, let him enforce it. And John Marshall had no Old Hickory control the Army. So this could be interesting. Question is, if the voters of Mississippi vote against both initiative number 42 and 42A, does it make any difference whether 42 or 42A passes?
I don't think it does. If the first vote is no change, then they're not going to care which one passed at the second phase. You're going to have to get over the first hurdle to get to the second hurdle. So, for statistical analysis, somebody may tell you which one carried the day, but it will not matter.
But if the first part fails, the whole thing fails.
That's correct. That's my understanding, that you have to get over the first hurdle.
If it passes and you don't vote for the second one, then you're not.
You're in the courts.
Yeah, right. Well,
and that's where
You've got to vote.
you need to vote
right.
Both times.
Right.
You don't vote for the second.
Need to bubble both times. If you're not for 42, you want to bubble the bottom bubble on both weapons.
Right.
If you're for it, then the opposite of that. Yes, sir.
It's my understanding that the first one will have to get a percentage of whatever the governor's vote is.
There is a caveat, and I've tried to stay out of that because I don't want to confuse people. But legally, yes,
yeah.
There has to be a certain percentage of people, because some people were saying, "I'll just not vote for it, we'll undervote it, and that will defeat it." I think that is a very risky policy. I would say vote.
All the initiatives that we've ever had in the state of Mississippi, 93% of the governor's vote is the least they have ever had. So, I mean, that argument is
expectation is they'll have enough.
Yeah, it will not happen.
And I challenge it, and it is a challenge, because keeping in mind, proponents of 42 have been working on this for a couple of years and sharing, and their position. And now here we are at the finish line saying, "Oh, none of that is true that you heard." I can see that's a difficult proposition to swallow, and especially we're dealing with the public school system. And we want to be very clear. Republicans are not against public school. I'm a product of public school, believe in public school. I don't believe in opening a door for litigation that will hurt this state, and I think in the long run hurt our school systems in total.
You're saying that where they said here is the debtors, the entire amendment, that all of this is actually left out of the amendment?
That's correct.
As it's written?
That is, and they...
I get a lot of arguments from the proponent saying, well, you haven't read the whole thing. You haven't read the whole thing. Well, apparently the whole thing is not what they think it is.
Their petition, and I don't want to speak to whether someone's intentionally misleading.
Because they're reading, my friends are reading the bottom part thinking it's going to be in the amendment.
And if you look at it, it talks about amount and source of revenue required to implement the initiative, and we don't know that that's not a moving figure anyway, so that within itself would be kind of hard to say. But for the purposes of the initiative, we have basically set a minimum standard. This is their opinion. This is what they say should happen, and it's how they would accept it being phased in. That's how they have promoted it. But no, that is not. It is not, and that's why. And this is not from a you know, Pro 42 website. This is the Secretary of State's office has to be neutral in elections. This is in red, and that's why I can put it on the front. That is the language of the law that we're voting on. And it does not include, this.
I don't understand why the superintendents don't make that clear to their teachers, because the teachers think they're gonna get more, be fully funded, and that's not what's there.
And that's the difficult
That's troubling.
It is, and that's why, and I've stayed, you know, probably, I spent a lot of time at a lot of meetings not saying anything, trying to listen to both sides to make sure that I understood, and on top of that, I'm for public schools. So I wanted to make sure I understood what was going on. After looking at the language, and again, and if I'm wrong, somebody please, you know, give me a call and tell me, but the Pro 42 website does not put the language up on their website, and that to me says enough. It says a lot, because if I wanted you to vote for something, I'd want to share with you what it was. You know, I just ran for office, and I sure didn't try to hide my name wherever I went. I wanted you to see my name, because I wanted you to remember that when you went to vote. And here we are hiding the language of what we're asking you to vote for. And so I would encourage you again to share with your friends, and politely, because we've got some people that feel very strongly about this issue in total, but would not vote for something that is damaging if they see it as such. And the fact is, the language does not mention funding. It does not mention the MAEP formula. And it is not a 7-year phase-in that is a suggestion of the proponents. So that's all right. That's good music.
Another thing it says in there, and on their, even on their thing, it says that the at least 25, not less than 25% of future increases in general fund and other tax collections.
Well,
right now they're already getting 62 to 3% of the general fund, so. But they're reaching out now to other tax collectors. I mean, that's what they say. It doesn't say that in the law.
Well, and again, right, the funding, even the proposal, and they don't deny that at this point, and they also don't deny that it fails to mention MAEP in funding. You know, although that's what we worked off of for a year and a half, and I want people to be able to vote their conscience, but you can't vote your conscience if you don't understand what you're actually voting on. So look at the language, you know, and my concern is the language in the use of adequate and efficient, I believe, opens the door for anyone to make an issue of something that they deem personally inadequate and inefficient.
And it changes our Constitution.
It is. This is not something to be taken lightly when you're changing the Constitution of the state. And it's not something that the legislature, I heard some people say, well, the legislature can do X, Y, or Z. The Constitution is the supreme law of the land. You have taken the power from the legislature as it relates ultimately to education, and you put it in the hands of the judiciary, particularly likely, you know, Hinds County Chancery and potentially the Court of Appeals as we move through the system.
There's an example of that. It's in Washington. They go before Congress to get things done. Congress turns them down. They take it over to the Supreme Court and get it done, and it winds up being a law that the Congress wouldn't pass.
And I think
that's the same sort of thing.
it's true,
Same sort of thing.
And even worse because we're dealing with the purse. And we've always put the funding issues in the hands of the legislature. And as you pointed out earlier, if a judge comes down with a ruling and they elect to follow that ruling as we would anticipate they would, it would be that money would have to come from somewhere else. There's no other way.
It's also troubling to me. It says K through 12. So what about the funding for the junior colleges and our universities? I mean, there wouldn't be anything left for them.
Well, they're a separate issue.
Yeah.
You know, and there's one other thing that has been brought out You know, and again, I keep going back to the same thing. It doesn't say what they say it says. You know, don't tell me what your law is going to do. Tell me what your law says. I'll figure out what it's going to do. But one issue that's also out there is that we talk about a system of free public schools. System is also subjective. Is my system K through 12, or does my system, would it be more efficient and adequate to say, well, we need to start at 2 years of age, 3 years of age? What if someone says textbooks are inefficient, everyone needs an iPad? I'm going to sue because of that, because I think it's there. I think as much as your mind can imagine could be something that you could claim. That doesn't mean you're correct. But, ladies and gentlemen, I see lawsuits all the time that I don't think are correct. But someone has the right to go in and say, in my opinion, because that's really what we're saying. In my opinion, inadequate and inefficient because of X, Y, or Z, or we would be efficient or we would be adequate if you did this. And so I think it opens the door not just to funding, to curriculum, to the system itself. I mean, it's not what it's purported to be, and that's my biggest concern.
Someone famous said, pass it first, we'll read it.
Well, yeah, I don't want to pass it to figure out what its actual end result is. That is troubling. Thank you, and I hope that helps and to share with your friends.